From San Antonio, Texas, home of the Alamo, the Riverwalk, and the World Heritage San Antonio Missions, this is the ExitMap Podcast, hosted by John F. Dini, the exit planning coach. Designed to help advisors who work with business owners, John talks with top professionals in the exit planning field about best practices, marketing tips, and how to be more effective when working with owners. Now, here's John F. Dini.
Welcome to today's edition of the Exit Planning Coach Podcast. I'm John F. Dini, and my guest today is David Jean. David V. Jean is having his third visit to the podcast. The first time we did, typically advisor tips. He also sat in on our panel when we had a panel discussion. And this time I asked David to come back because I'll tell you a little bit about David first. David is a partner in Albin, Randall, and Bennett in Maine. You're in Portland, right?
Portland.
Yeah, in Portland, Maine. He is head of their construction and real estate practice. He is a certified exit planner, and he does the 7-step planning system. He is also, are you still the managing partner of New England Funds Control, LLC?
That's correct.
What is that? What does that do?
That's really an escrow arrangement sort of firm, sort of on steroids. So we do escrow arrangements, but they're really usually related to contract-related escrow arrangements.
Oh, okay.
So yeah, it's pretty exciting.
And he is a CPA through and through, as you can tell from his definition of what's exciting. Yeah. But I asked David back today because he did a presentation a couple of years ago that I sat in on in Denver on things that can go wrong in buy-sell agreements. And it was a stitch, and it was certainly cautionary for anybody that works with business owners. And in the course of exit planning, we always look at buy-sell agreements. So, David, this is going to be a little freewheeling, but I'll throw it to you. What's the worst story you have about buy-sell agreements?
Well, before I get into that, I got to be remiss, John, if I didn't mention that during that session that I presented, I actually called you out, if you remember, of your business, of the ExitMap, and how much you contribute to the exit planning advisors. You sent me a bottle of bourbon.
I did.
Years ago. So, of course.
Although, as I recall, you mentioned a longing for a $13,000 bottle of Pappy Van Winkle, and that's not the bottle I sent you.
That is correct. And you sent me a bottle of a $50 bottle. So I'm hoping that this podcast will earn me a little more respect. But thank you. Things that you touch on. There's just so many stories. I think the one that stands out. And these stories are never good, right? They usually don't end up in a happy place. But back a number of years ago, I had a situation where I was engaged by an attorney to do some forensic work. And what happened was there was a buy-sell agreement that was in place, executed, and there were 4 owners. If I recall, I think there are 2 owners. I think had about maybe 35-40% each ownership, and the other ones, I don't remember, but 5 or 10% ownership each. And this was an architectural engineering firm, been around for a while, very, very profitable historically. And on this given year, 2 things happened. They expanded into a couple of different cities, into some large, metropolitan areas. That was a real, it was a very expensive maneuver. Didn't quite capture the business they were hoping to. And really lost a lot of money in this particular year with that expansion efforts. On top of that, they had a lawsuit, and there was a large settlement, and there's a lot of legal fees. So it was one of those years where sort of bad after bad happened. And so what ended up happening is that in the buy-sell agreement, the value of the shares was to be a calculated value, and that calculated value was basically a multiple of EBITDA. So the first year in the history of the company, they lost money. And if you take a negative number and you multiply it by a number, it's a bigger negative number.
Right.
And so
Funny how that works.
yeah,
Yeah.
so essentially the value was zero. And the way it was written is that the two owners that had a higher ownership percentage could basically, with a 90-day notice, invoke their agreement and buy out their shares. Well, guess what? They bought out the 15, 20% to zero, when in fact the company had intangible equity. I mean, it had goodwill, it was worth a lot, but the calculated value does not reflect at that particular time the value of the company, not even close. So we were just engaged to kind of go through the books and go over the calculation just to make sure that there wasn't, sort of what I'd call gamesmanship being played to devalue the business and get these folks out. So that was tough. That was a real difficult situation, but it's just another example of buy-sell agreements that aren't properly thought out or well thought out. And I've never been a proponent of calculated values unless it's a company that's highly stable, predictable. Maybe it's a percentage of revenues, or maybe a multiplier of revenues, something of that nature, where there's a lot of stability, but not in a situation where you're just relying on an EBITDA number. So that was the one that really kind of struck out. This was a number of years ago, and that was sort of the turning point where kind of recognized that these agreements. This is, a shareholders buy-sell agreement is the most, or not LLC operating agreement. It's the most important document a business has. It's critically important. And so from that sort of moment on, it was sort of an aha moment, and I really became a lot more, I guess, interested and getting more involved in buy-sell agreements and really helping companies structure them, properly.
I was just looking at one this morning for about a $50 million revenue company, retailer, and it's unsigned. And nobody can come up with a signed version. And there's some contesting going on about what it says. And I don't know that they have a valid buy-sell agreement.
Yeah.
You see that a lot, right?
We see that a lot. Another major. This was quite a few years ago. And this is actually a common problem. Is that oftentimes in a shareholders agreement you'll say that it's the value will be based on independent valuation and based on fair value and those sort of things. But oftentimes it doesn't carve out that the value should exclude any sort of life insurance proceeds from any company-owned insurance. And we've had situations I've seen in the past where the cash proceeds were $5 million. You got two owners. All of a sudden, the owner's paying 50% of the proceeds for additional value. And the purpose of the proceeds was to pay for the shares, not to enhance the value of the shares. So we always make sure that it's based on fair market value. If there's any company-owned life insurance or value, we just put an agreement just excludes any sort of life insurance. That the purpose is not to have that as an investment.
Sure. Yeah. Well, and it can be that is confusing. I had it was a value question, not a buy-sell question, but I had a client a few years ago, and I took a look at his company and his cash flow and said, I think you're worth about $2 million. And he was highly offended. And he said, well, I just had an appraisal done, and it says I'm worth $5 million. And I went through it and talked to the appraiser. I said, can I talk to the appraiser? And, he said, that was done for an estate. His father has $3 million worth of insurance that the company's been paying for. His father passed away. He's got a $3 million policy sitting in there. I had to put it in the valuation, but that doesn't mean the enterprise is worth that kind of money.
Yeah. And the other thing too, on that line, and I can't speak for other states other than the state of Maine, but there's been a lot of precedents in the state of Maine with respect to buy-sell agreements in terms of the words fair market value and fair value. And absence to any sort of definition, a fair market value under the state of Maine is a discounted value, like marketability, premiums, discounts, and so forth, whereas fair value is considered to be enterprise value. So just that nomenclature alone could have significant impact to valuation. So sometimes, there's a lot of details, and words mean something.
Yeah.
Uh, Words mean something, so you just want to make sure you have the right meaning.
Especially when you sign them and file them with the state. They tend to mean something.
That is absolutely true. It's kind of interesting. Right before we recorded this podcast, I was literally just coming out of a meeting in a family-owned business where you have multiple family lineages. There are two, so basically the two brothers started the business, then you've got children that have now gotten into the business and so forth. And one of the owners is looking to get out, and it's kind of interesting. They have a fully executed buy-sell agreement, but the other side doesn't want to honor it. So we're in a situation where we're going to try to work with the family to try to kind of use that as the framework and hopefully kind of negotiate a deal. So even when you do have an executed buy-sell agreement, particularly in a family situation, you got people who are saying, "Well, I didn't understand it when I signed it. It's not what we meant." So, you can always pull out that card if you have to, but that's sort of the last, right? That's the last thing you want.
Yeah,
to do.
that means we're going to fight.
Yeah, we're going to fight.
Yeah.
So we're trying to avoid that. But
what about another thing that I'm sure you run across as much as I do is unfunded. Unfunded buy-sells. How do you approach that when when a spouse typically says, well, this was in my husband's papers and it says he's going to get X for his shares of the company if he passed away, and I want X, and there's nothing there to support it.
Yeah, I mean, I think funding for death is the easiest, is you just take out some insurance policy. So any agreement that we work with our clients, we always look at, A, are you insurable, right? B, how much insurance do we have, and what type of insurance are we going to have, and who's going to pay for it, and those sort of things. And how's it structured, company owned? Is it a cross purchase? Do we put it in a special purpose trust or entity? Those sort of things. So, death is easy. That can easily be funded. Disability.
No, I'm talking about the situations where let's say two partners, always meant to buy insurance.
Oh, but didn't buy insurance.
Yeah. Yeah. How do you approach that with a bereaved spouse who has been told she's got X number of dollars coming because her husband died?
I think then there's one of those reality checks when there isn't any life insurance that exists, and you have to take a note for some period of time.
Mm-hmm.
Those are tough situations to have. I haven't had many of those, fortunately. Although I take that back. Real quick story. This happened the year after COVID. So this would be 2020, 2021. We took over a client, and when I was going through the buy-sell agreement, it's usually always one of the first documents I look at. There are three owners, relatively around the same age. I'd say within 5 years. The oldest shareholder was uninsurable, had a heart condition. So what happened was the other two owners, because they couldn't get insurance on that owner, they said, we're not going to bother getting any. So this is a true story. And when when we talked to them, we went through it. I said, you guys got to do this. I mean, you guys got to get insurance because bad things happen, unfortunately, and they're unexpected. 2 years later, a second shareholder had cancer. His terminal cancer, passed away about 2 years ago, and they had obtained life insurance prior to that event. So they were able to use the life insurance to pay the estate the entire amount of the value of the shares. And I think that's really important as advisors, making sure that bad things happen, and they're unexpected. But if you're insurable, at least cover yourself, in that event. So I think as advisors, it's really important making sure that there's some life insurance that are.
Yeah. The story you opened with was owners that had a right to call based upon a valuation and did so in a year of bad valuation. Have you ever seen the opposite, a put option where they have an exceptionally good year and somebody says, that's it, now I'm selling?
I would say not often. I think more often than not, I find that retirements are often planned, or perhaps they may be centered around a collection of maybe multiple years, as opposed to my experience is that while we had one good year, I'm going to sell my shares. But I think when the values start to get high, then people start to realize, well, maybe I want to retire
Right.
a little early. But the one thing that's really, really important in any of those agreements is I believe in due notice. So I think you should have at least a year due notice, because if the show is going to leave, you got to find someone, you got to train someone, you got to, develop them. And in fact, I take it a step further. And if it's below a year notice, then I usually recommend that there's a penalty provision where that they get a discounted value of their shares. And the reason for that is quite simple, is that's because you're putting the company in harm's way. You're putting them at a disadvantage. Now, I'm talking about voluntary termination. I'm not talking about disability. I'm not talking about death,
Sure.
where that notice, it's pretty hard to give notice when you unexpectedly die. But I think that having that penalty provision is really, really important. And for bigger companies, or if you've got someone that's really in a very prominent role or an important role, or very difficult, maybe it's a 2-year, a two-year window. And again, I just think that that's just so important. And at the end of the day, this buy-sell agreements is really not only to protect the individual shareholders and their families, to protect the business, to protect the employees. It goes beyond just the shareholders.
Right. So the other stakeholders. All right. So what I have here is I have five things that we should be looking for as advisors. Number one, the buy-sell is the most important document, and make sure it got signed and everybody knows what it says.
Yeah.
Number two, avoid formulaic values, that are manipulable or can be subject to a single event. Number three, fund it. Make sure there's insurance in place, or if there's not, that people understand that they're not just going to get a check. And that's, I don't know if you do it in Maine. I mean, I have always done spousal signatures, spousal acknowledgments of whatever the buy-sell says. The spouse cannot claim ignorance of it, with all the language that says I've had the opportunity to talk to an attorney and all that stuff. Number four, any approach to valuation should look at multiple years, over some period of time, and then finally a clause that says voluntary termination should not harm the company and be at the detriment of the company. Anything else we should make sure?
Well, there's so many provisions. I think another one that I like, and I'm dealing with this situation, deal with a similar situation, but I've had this situation past years where there's no mandatory retirement. Now, ownership doesn't necessarily have to run parallel with employmentship. I mean, you can still be an employee, get paid, compensated, but just not be a stockholder. Those things don't necessarily have to be parallel. But
Right.
what we're seeing here, and I've run into multiple times, is that there's no mandatory retirement. So now you got one of these owners who's in their 80s and now dealing with dementia issues. And I've run into this where, we're trying to execute, various transfers of ownership and valuation. All of a sudden you have someone who is, because of the mental condition, is really become problematic. They're resisting to it, don't want to do it. And I'm a firm believer that, and you can argue that maybe that should come under the disability clause. If you had a disability clause, and you have to define what that disability is, which would be mental impairment, which sometimes is difficult to get. But having that as, we're trying to avoid the old man in the corner that's just collecting a paycheck and not doing anything. So I can think of so many, but these are the ones that are just sort of come into play more frequently than you would think.
Good. Well, very helpful. It's great to talk to you again. It's always great to talk to you.
You're a great guy. appreciate everything that you do for
Thanks.
for our district.
Well, and we know in the other meetings that we have with our various advisors and subscribers in ExitMap, you are a frequent participant and a big help there too, because we do brain trusts where we share different things. So, pleasure having you on again, David. Always good to see you. I'm jealous of your weather. Yes, it is less than 100 degrees in San Antonio at the moment, but not much less than 100 degrees. And you guys get rain and all those other good things, that we would like to see. But terrific to see you. One last thing we should always do: your website and contact information, if people want to get a hold of you and ask you questions.
Everybody's welcome to. The name of our firm is Albin, Albin, Randall and Bennett. We're based in Portland, Maine. And we also have a sister company called Altus, ALTUS, Exit Strategies, which is our exit planning consulting arm.
Okay, great. Thanks a lot, David. Have a terrific day.
The fastest way to lose a client is to treat the exit as the finish line. The surest way to keep one? Make what's next part of the plan long before any transaction. ExitMap changes everything and turns next step planning into your strongest retention tool. ExitMap is the only structured discovery system built to be the first step in every advisory relationship. The 5-meeting process helps advisors guide owners through the essentials of successful transition planning: financial readiness, business readiness, and personal readiness, so they gain real clarity about what life looks like after the business. You guide the process by facilitating deeper conversations. They own the plan by discovering their own priorities and defining what success truly looks like. The result? A documented set of goals, a personal vision, and a prioritized action plan. Built by the client, giving them clarity about their future and giving you a roadmap for supporting it. ExitMap. You guide it, they own it. Take a test drive at exitmap.com